take a moment and like the video. Hit the subscribe button. Hit the bell so you can know when I go live. Please comment where you from to support this channel. Please give me a like and a comment. Let's go.
Close friends with the decedent that has nothing to do with any crime, and for Mr. Walker to just use the FIT as a blanket to not testify at all, this is impermissible, and we would have been calling him, and I just wanted to say that and put that on the record. Regarding my motion for mistrial, previously, and for the record, the court previously in December of 2022 asked our defense counsel to file responsive pleading in reaction to Mr. Shields filing a motion to strike all my witnesses. The court denied that, but the court ordered me to file something, a nexus between all my witnesses and what they have to do with the case. Although that seems like an impermissible roadmap to my defense, I did it anyways. I believe that the reason that the court did that, and I can't think of another one, is simply because there was a lot of celebrities and celebrities on my witness list. Unfortunately, the decedent in this case is a celebrity, and I have stated many times, and I'm stating today, that because of that reason, many of the people on my witnesses were celebrities. In addition to that, I filed a motion to perpetuate, and I added affidavits for myself and for my investigator stating that Mr. Livingston Allen and Mr. Aubrey J. Graham were witnesses to this case, and I was asking for the court to grant a motion to perpetuate their testimony in the event that they would not be available for trial. The court denied both of those motions to perpetuate, and specifically regarding the motion to perpetuate the testimony of Aubrey J. Graham, the court indicated that it was denying it, but that put everybody on notice that if we do take the deposition, give it the same scrutiny that you would as in court testimony, because if he's not unable to appear, that we would be using that deposition transcripts at trial, which was weird because it was kind of like granting the motion to perpetuate, but not really. So we went forward, and eventually, I served him, Mr. Graham. Mr. Graham failed to appear. I presented the court the proper affidavits, the certificate of non-appearance, and the court entered on my motion an order ordering Mr. Graham to appear to deposition or appear before this court on the following Monday to find why he shouldn't be held in contempt. During that time, after that time, before that, I also alerted the court that Mr. Livingston Allen, who had been properly served to attend this trial, and I was trying to get a motion to perpetuate his testimony, had stated publicly on his podcast that he was actually evading service and that he would have nothing to do with this case. Once we had an order ordering Mr. Graham to appear, Brad Cohen filed a general notice of appearance. On February 13th, the court heard Mr. Cohen's motion to quash, and although it granted Mr. Cohen's motion to quash, the court gave certain instructions or gave some language while the court did in fact grant his motion. The court said that that it would do certain things on behalf of Graham. It would limit the topics, and I think the court said that it wouldn't give me the questions, but it could narrowly tailor the topics. The court said that maybe it would only be as simple as asking several questions, and I believe the court at that time gave sample questions. So it basically hinted at the narrow parameters that deposition would be. It talked about sealing of the deposition so that it wouldn't hit the media, and it talks about the balancing test about privacy rights and constitutional rights of the defendants. And you also told Mr. Cohen that at some point, regardless of the defects that he stated in the affidavit, that at some point that I would get it right and I would properly serve him. On the next day, February 14th, I went ahead and I served Mr. Cohen's office, and I also served Drake at the Beverly Crest, his $80 million mansion, and that is a very public purchase that he did, that he bought it from another pop star, and he visited the Beverly Crest. Brad files then a motion for, I filed then a motion for expedited deposition because Mr. Cohen already articulated to me that he's not accepting service. Mr. Cohen then files a motion to quash and a motion for sanctions against myself, asking the court to sanction me for, I guess, even bothering Drake, and a motion for protective order. We come in front of the court on February 24th, and at that time, I called James Baird, the 81-year-old process server. The court prohibited me from showing video that was taken memorializing Mr. Baird, the service of Mr. Baird, even though Mr. Cohen had, in his affidavits, made claims that were against what I was saying that occurred on when Mr. Baird attempted to serve Drake at the Beverly Crest. Mr. Cohen then tries to stipulate to Mr. Baird's affidavit in an effort to avoid the video from being used as evidence, and Mr. Cohen then educates everyone in the court regarding California law and the two parties, and that it's a two-party state. I was able to articulate to the court that I guess he was referencing to the California Penal Code 632, which I cited on the record, which involves confidential communications. I argued to the court that a process server trying to serve papers at the gate of a mansion and talking to an armed guard could never be the confidential communication that is intended by California Penal Code 632. At some point in the hearing, Mr. Cohen viciously crosses the 81-year-old process server and calls into question his hearing, his veracity, details of the service, whether the document was in an envelope, whether he posted it or didn't post it, conflicting details that could have been seen in the video. I then again tried to get the video into evidence. The court on a second occasion refused to allow me to use that as evidence. At some point, for whatever reason, in a motion regarding a process server and whether service was properly effectuated, I was not allowed to use the video of that service. When I was arguing my motion, it became clear that, and I think the court also articulated that, why am I involving Mr. Graham when he had nothing to do with this case? And I think the court actually articulated the negative implications that this would have for Drake. This is the first time that the court does this on February 24th. So then one would ask, what happened from February 13th to February 24th? Because the entire time, everybody's known my defense because I had to say my defense and air it out in December of 2022. All of a sudden, February 24th, I'm getting admonished by the court for involving this individual. So one would ask, what happened from February 13th to February 24th? Well, what happened during that time was Mrs. Shields on direct of Detective Curcio asked him straight up, did Drake have anything to do with this? Is there a Toronto connection? Now that's different than me asking on cross-examination a question that's sustained. That is the state attorney actually putting the name out there in front of the jury to a detective and getting a response that's not objected to and that's on the record. Additionally, the detective asked, when Mrs. Shields asked him, were you able to even verify whether he was in South Florida on June 18th of 2018 or something to that effect? And he said that he was able to confirm it. When I crossed him, he said, yeah, I was able to confirm it because Detective Foster checked social media. In any event, it came out on the record that Mr. Graham was part of their investigation back in June of 2018. That is years before I listed him as a witness. That is years before I tried to take his deposition. It came out that BSO was trying to verify his whereabouts at the time of the murder. If BSO is trying to verify your whereabouts at the time of the murder, you are either a suspect or a person of interest. On that alone, I should be able to take his deposition, but that didn't happen. Those are things that happened in between February 13th and February 24th. Things that would encourage my ability to take his deposition, but that didn't happen. So the court granted the motion for protective order. Sensing blood in the water, ASA Shield stands up and says, I move to strike all of his witnesses. As irrational and illegal as that sounds, that's what she did. She moved to strike all my witnesses. The court says, nah, I'm not striking all your witnesses, but I'm going to strike Aubrey Graham. So the court struck the witness without notice on an or tennis motion brought from ASA Shields. And then in bolstering, the court in bolstering his decision said that, I don't even know if Drake even lives at that address. That is a fact that's never been an issue. Mr. Cohen never argued it. The affidavit from the security never denied it. So now the issue is, why is the court taking the position of Drake's counsel and making arguments that were never even made by Drake's counsel? Additionally, the court then included on relying on a family member's testimony that testified in a closed deposition in where she denied that she had any knowledge whether or not the decedent had issues with Drake. Something that I told the court was completely perjurous and nobody would ever believe it, but the court took that information that was in a closed deposition, not even privy to Mr. Cohen, and articulated it in open court. Now the court became a witness. And it's already been part of the court record, and I filed Cleopatra Bernard's deposition where she stated that the day of the actual murder, that the reason that she had security was because of the Drake and Migos beef. An additional piece of information that happened between June 13th between the 13th and the 24th of February was that Detective Curcio, upon cross-examination, my cross-examination, where he denied it, he had to admit that the word Migos came from the confidential cooperating witness in this case. The cooperating witness in this case a month after the murder, and he had to admit that he never followed up on that, but that in fact Mr. Allen and him had discussed Migos in July of 2018. Cleopatra Bernard said that was the reason that she had security that day. Curcio also states that Drake's name comes out of the Crime Stopper tips. Then the court, when I'm articulating to the court the reasons that I should be able to take his deposition, and I start giving sample questions, okay, the court says, well, do any of those exonerate your client? Now, that's not the threshold for me to be able to take a deposition. It'd be great if every question that I ask in the deposition exonerated my client, but that's not the threshold to allow me to take a deposition. The court stated that none of those things exonerated my client. So now we're in a position where, my client was in a position where he believes that the court is now biased against him and biased in favor of Drake. It argued the facts not in dispute.
We're not going to address that portion of the motion because we've already ruled on that. I'm only the motion of this one.
Okay, got it. So Judge, essentially because of the court's ruling on February 24th of granting an or tennis motion to strike all my witnesses, narrowly tailoring that motion just to strike Drake, the court has essentially gutted my defense and interfered with my ability to properly represent my client, and for that reason, I'll ask for permission.
Thank you. States, would you respond?
Yes, Your Honor. One of the first things I was looking up was Mr. Padilla's notice of appearance in this case was June 26th of 2018. It's important to point out that he has actually been counsel that's been on the case longer than anybody that's present in the courtroom. Also, he is requesting the wrong relief for, he's requesting the wrong relief by asking for a mistrial. The evidence has been closed and all parties have rested in the case. We've argued judgment for acquittal. We've argued for motion for mistrial with the two different standards. None of these arguments were raised. Instead, he took the option to join counsel, which was Mr. Kimmock at the time, his arguments and adopted his arguments, none of which addressed any of these. So I would argue that these arguments that he's making now, A, are not timely. He's waived these arguments because he did not make them contemporaneous at the time when they were supposed to be made. Additionally, asking for a mistrial after the close of evidence, essentially at the stage when we would be charging the jury and doing closing arguments is not timely. So for those reasons, I think it should be denied on its face. Additionally, it is not the first time that the jury heard anything about Drake. Drake and any parties that were not part of this case came from Mr. Padilla's mouth. At voir dire, at opening, initially when Mr. Allen was on the stand, it was Mr. Padilla that asked in his questioning of Mr. Allen, which was sequentially in the chronological order of the case before Detective Curcio testified. He asked on cross if Mr. Allen was on the set of God's Plan, which was a video that was shot by the artist in South Florida. He asked if Mr. Allen ever met Drake. He asked if he ever went to Toronto. He asked a lot of questions about Toronto and if there was any connection, or if Mr. Allen's father had any connection to Toronto. Those all came from him, not from the state. The state was put in a position, first of all, in the state's opening, I laid out what I believed the evidence would show. During my case in chief, I was put in a position, and as litigators and presenting the state's case, we always have to potentially address certain things that may come up in rebuttal or defense, because I don't know if I'm going to even have an opportunity to rebut. That's something that the court would have to allow. So I have to be able to address not only my case in chief, but potential defenses. And so in that approach is how the state asked questions in response to some of the things that Mr. Padilla brought up. Next, at the time that Mr. Padilla's motions or his witnesses were stricken regarding Mr. Graham, and there was also Linwood Walker that came up from Miami-Dade County. Mr. Padilla did not ask for continuance at that time to try to cure any defects in his defense. Any type of objections contemporaneous that would address that, so I would argue that he waived those. Additionally, at the close of Mr. Padilla's case, the court gave a lengthy colloquy to all the defendants, but specifically Mr. Williams, and asked Mr. Padilla, outside the presence of the jury, are there any other witnesses that they would call? Both said no. He didn't mention anything about any of the witnesses, even though he had listed 57, 30 of which were with the state. He could have easily called them. I know that Mr. Kemop did. He called state witnesses. Mr. Padilla never did. He never tried to perfect any of the issues or any of the problems with his service. And I would argue that because he did not make contemporaneous objections or address it at that time, even the defendant himself did not raise an issue and say, Judge, I want Mr. Padilla to call Drake. I want Mr. Padilla to call Linwood Walker. I want him to call all these witnesses. He in fact sat silent and mute and said that he was fine with the defense. And for as far as we knew, it was simply strategy as to why he did not attempt to call anybody else. And I would argue that because at that time, during the colloquy, before the court had moved on and he rested in front of the jury, he waived those objections that he's trying to raise now, and they're not timely. He also addressed something about, not having the opportunity. Because he's been on the case the longest, Mr. Padilla attempts to make an argument that the only opportunities that he had to do any of the work that he's referring to is right before trial or during this time. I would argue that he could have done any one of these things, including serve Drake, serve Linwood Walker, since June 26, 2018, when he was retained as counsel. So because he failed to do that, and that's on him, for whatever reason he has not done that, that does not then make it an issue for this court to then try to delay the trial or delay his client's right to a trial after sitting in custody for 5 years to say, well, the court didn't allow me the opportunity. He chose not to do it for 5 years. That's on him. Additionally, he never asked for a motion to address the service for any of the other parties that he listed. And the comments that he's making about, you know, the sua sponte motions or whatever it was that were happening at the time, it's not sua sponte. This was his burden to prove that A, service was proper, and proper at the correct address, which is the residence of the party he is seeking to serve. He didn't do any of the sort. I sat through that hearing and I watched everything that everybody saw. He chose to put on that particular witness that had those issues and essentially was being combative with the court, whatever his hearing was or whatever it was. The fact that it didn't work out for him, that's his choice to put on that witness. And his burden to prove the things that he's claiming and alleging. Because he didn't do that, I would argue that the motion for mistrial should be denied, not only on its face for having requested the wrong relief, but also for all the reasons stated therein. Lastly, he's not stating anything new in his motion that he hasn't already argued before. Essentially, this is like another stab at it, where with the court's ruling, he also should have, if he had took issue with the court's ruling, should have filed a motion to hear the hearing again. I believe that's a 10-day request. That's not timely because he would have had to have done it within 10 days after the court's ruling to ask for an additional hearing for it to be referred. He didn't do that. So essentially, I think based on all the above reasons, it should be denied, and we should proceed to the charge conference.
Judge, I'll just say that it took 5 years for Cleopatra Bernard to actually sit for a deposition. The reason that I never listed witnesses that I did was because it was obviously a fact-finding process of depositions that had not been taken. Regarding James Barrett, I just want to say, I want to publicly say, he can hear. The problem is the audio that was there that day. If I would have been allowed to show the video that I wasn't unable to show, it would have shown him having discussions and being able to talk and hear perfectly fine. James Beard can hear, and that's basically it, Judge. One thing is being able to defend a case like this regarding celebrities. No one can tell me that if I file a witness list, that's going to hit the media and that's not going to affect the deposition testimonies that didn't take. Important deposition testimonies that took years and years was Cleopatra Bernard, for no reason. It took years and years for us to take a deposition, and then also Robert Allen. So I'm sorry, as a strategy, I am not going to file a witness list that's going to interfere with my fact-finding process, and that's the reason that it took so long.
Okay, thank you. So, addressed as a motion for mistrial, it largely reflects disagreement with adverse rulings by the court and not information or things that happened before the jury, and which would be proper motions for mistrial, which should be contemporaneous. This is more in the nature of appellate issues and not, adverse rulings during trial are not grounds for mistrial. Mistrials are for something happened in front of the jury which cannot be corrected. So it's really not the proper form for this either. Let me note that the whole witness question started out as a motion to strike by the state all of the witnesses, which I declined to do. And the request for counsel to provide some nexus was in a response to the state's motion to strike everyone. I said, show me how they're relevant and we can move forward from there. The court's advice to take any depositions if they were to happen with an eye to a future motion to perpetuate was just cautious guidance. In no way should be interpreted as the court granting those motions, because the court clearly did not grant motions to perpetuate testimony which no relevancy or nexus had been shown at the time. Merely the court was saying, I was not going to stop you from conducting discovery in those areas should you feel it necessary. With respect to Linwood Walker, we had a hearing on that. Mr. Walker is represented by counsel. Mr. Walker indicated that he was asserting his Fifth Amendment privilege. The court has no ability to go beyond that, and the court indicated that I would not allow you to call a witness merely to come in. He asked a question that he was going to assert the Fifth to, and then be taken away. That would be improper. That's Linwood Walker. With respect to Livingston Allen, which you raised in this motion, there have been no other motions before this court with respect to Livingston Allen. You've not made any requests, so it's just not grounds that you're bringing up at this time. With respect to the show cause that came on the one witness, Mr. Graham, the first hearing that we had on that, the court ruled that there was not proper service. We had a second hearing, and I did encourage counsel to work together and see where it could go. That's not the same. Court's encouragement, court telling people to get along, play well in the sandbox, to do things to facilitate moving forward, is not the same thing as a court order, which either is expressed as a court order or comes out in writing. When I say, why don't you guys get together and see what you can't do, that's merely a court's suggestion to see how we can facilitate. But in no way is a court order or directive. Counsel indicates that, and in the second hearing, my function is to determine whether or not there was proper service, and counsel's statements of like everybody knows or it was highly publicized. Again, there was no request for judicial notice, and what everybody knows or what's out there is not evidence before the court, and it has to be proven like anything else. The court was indicating to counsel that its motion for further relief through show cause or writ of attachment did not have sufficient evidence. If the counsel is indicating that its arguments made on that day about the perjured testimony was with respect to Mr. Bernard and the deposition, again, that's some discovery documents that you took that are not with the court. The only testimony that was in trial with respect to that came from Ms. Ellis, who testified on the stand, and that's what the court was referring to when she said, I don't know of this. Okay, so there is no evidence of everybody knows or it's well established or whatever else. I don't know, and those things have to be proven through evidence before we can do that. With respect to the questions about whether or not this could exonerate, again, it goes back to relevancy. The court has a function under 612 to not waste the jury's time, not to chase irrelevant issues, to limit the scope of examination, to not, again, get into misleading or irrelevant areas. And when the court asks questions about that, it is to establish, offer counsel an opportunity to establish some form of relevance. In this case, again, any other witness that was listed on your witness list was not specifically brought forward or further relief requested, and the court in no way prohibited you from attempting to take depositions of any of those witnesses. With respect to Mr. Graham, we had a number of hearings. The court made rulings that there was not proper service, and counsel never was able to establish any relevancy to the court's satisfaction. That's why that witness was stricken. That is a matter for appeal, not for mistrial. So your motion for mistrial, for those reasons, is respectfully denied. Now, Mr. Rares.
Thank you, Judge.
Also, state, although the motion for mistrial should be contemporaneous to the event as it happens in the case, I would not say that a motion for mistrial cannot be had after both sides have rested, because oftentimes a motion for mistrial can come up in closing arguments, which happen after this point. Either side could do something that would raise that issue. So I don't believe that you can't raise a motion for mistrial at this point, but again, it has to be contemporaneous to the event so that the court has an opportunity to hear it, if it can, through a period of instruction. Which brings me to Mr. Rares.
Thank you, Judge. You set the stage for me marvelously.
Thank you.
Judge, my motion is couched in a renewed request for mistrial and/or curative instruction. In all candor, what I'm really concerned with is curative instruction. There are a number of times the court has read curative instructions, I think quite properly, to the jury in this case. There comes a point in time when cumulatively we have to look at the effect of that overall on the jury, but I'm not making that argument at this point in time. However, just to set the stage as to how this happened with Detective Curcio, we were very late in the day, Your Honor. This was about 4:45, if I remember correctly. It was on the state's redirect to Detective Curcio. When I asked about some of the tip material that had come in, candidly, it had a previous sidebar. I pointed out that while one counsel had received all these tips, the other two counsel hadn't. So I did get those materials from Mr. Padilla and go through them and found some things there that I thought might be helpful to bring to the jury's attention, such as the fact numerous individuals in those tips were posing with money. But that's the only thing that I was asking Detective Curcio about. And in fact, eventually I withdrew that and didn't even go forward with the photos that I found to verify that Detective Curcio had in fact seen that. But what happened here, Judge, because it was late in the day and I was tired, I thought I screwed up. I thought I asked something stupid and opened the door to this testimony. So I made my objection. I proceeded sidebar. I asked the court to consider it. You overruled my objection. So I wrote a transcript to see if, in fact, I had done anything that would make the testimony of Detective Curcio somehow admissible, as it was double hearsay, in my opinion, had never been followed up on by Detective Curcio or anyone else from the state attorney's office to make it in any way admissible testimony. Judge, what the state did is they took a question clearly, and it's in my motion. The first question by Mrs. Shield on the redirect regarding my cross of Detective Curcio was, Mr. Rares asked you on behalf of Mr. Newsom that you received a lot of tips regarding black males flashing money, or black males and money, correct? Yes. However, she says, there was one tip or information that you received that was very specific to Mr. Newsom. Judge, the moment she said that, I made my objection as outside the scope. I think it properly was outside the scope. At that point in time, I had asked nothing about any information that he had received extraneous to the tips, which was how she segued into getting him to immediately start reading from his report. Judge, the report had always contained reference to an alleged text from a phone number that was never traced to my client, allegedly by my client, with a picture of him attached containing what amounted to a confession. If it had been properly presented and documented by the state, that would have been an extrajudicial confession. So it can't be said that this is in any way harmless error, particularly in light of the lack of other evidence that the state has been able to bring against Mr. Newsom. So in that regard, Judge, I would ask the court, and I'll argue further, consider a curative instruction at this point, as you've done with a number of other things. This jury, I think, is well prepared to disregard evidence that they should not have received. But there was no way, and there is no way, for me to cross-examine that testimony. Detective Curcio, if you remember correctly, started reading very quickly from his report to get this into evidence. And the ruse that the state used, in all honesty, was regarding money buried in the backyard. The only thing I'd ever brought out about the search was that there was a search and there was a digging in the backyard. Never why there was a digging there, never what they were looking for. Certainly nothing to open the door to the hearsay evidence that gave rise to the search warrant being issued in the first place. And I think it was proper for me to point out to the jury on a number of occasions that there was a search, no evidence was gathered. I never went into what they were looking for. But to say that because I mentioned a search where nothing was found, I opened the door to the actual search warrant, the information in it, coming from a double hearsay source, that I never even challenged. I did not argue that that was not enough to get a warrant and go into a search. Because again, there was no admissible evidence based on what was in Detective Curcio's report. And the testimony went on. The text was purportedly from Trayvon Newsom. Yes, he named himself by name. And there was also a picture included. Yes, depicting Trayvon Newsom. Yes. What did the text read? Judge, no text was ever produced to the defense. No picture was ever produced to the defense in discovery in this case. All this ever was this information in a police report. And I would argue to the court that without a lot more background work to develop that into admissible testimony, the state knew that this was not admissible. I, in fact, had discussed that with Mr. Lowe on a number of occasions over many years, who was well aware and would not have tried to introduce this without more. And it went on. Detective Curcio said, I will quote, it said, all my money buried, happy face, I got snitched on, so I saved it for if I don't catch life. Real shit, I'd be thinking I'd catch life, but I buried the bitch. I buried it at my house, and I get you pregnant. I stay out here and soon I'm going to dig up the money. I got like 8,000 buried, but I'll do 5 years, I'll be home before you know it. You straight with me turning myself in on Sunday. Judge, without providing that text, a picture of it, something, without them having a phone, without them doing anything to link that up to Trayvon Newsom, I would submit to the court that that was inadmissible testimony. It was double hearsay, and it violated my client's confrontation clause right for me to be able to challenge that in any way. And I would ask for a curative instruction, simply asking the jury to disregard that portion of Detective Curcio's redirect examination by the state, and that it led to testimony that should not have been offered before this jury.
So, Your Honor, I'm staying on the argument that we made at sidebar regarding this. Mr. Ramirez did open the door, starting with his opening, mentioning and harping on the fact that the SO dug up the backyard of the defendant is directly and fundamentally related to this text message. What has come out by Mr. Ramirez, or what he's attempted to point out on deficiencies in the state's case, is there's no evidence relating to his client. That's part of his defense. He didn't do it. There's no evidence relating to his client. And he wanted to be able to bring out, they didn't find anything in the backyard. Well, the search was precipitated by this text message. And the reason why we did not add more specificity to the text message is because the investigation that it came out of would have caused more prejudice and would have been more prejudicial to his client than probative, because it involved another homicide investigation. That's why we didn't say that. Additionally, the circumstances wasn't just about Mr. Newsom text messaging a girl. The girl that is the receiving end and the other party to this text message was attempting to solicit Mr. Newsom to commit another homicide unrelated to this case. So that's another reason why we did not bring out those specific facts in an effort to make sure that it wasn't more prejudicial than probative in this case. When he brought up the digging in the backyard, what he wants to be able to argue to the jury is, well, look, there was a search, nothing was found. Well, it's relevant as to why their search was even attempted in the first place, because what was discussed on his cross-examination was all the things that led to, or his argument, lack thereof, to his client. When in reality, there was evidence that led to his client, which caused probable cause to get a warrant to search the backyard. That's the complete picture. And Your Honor, I believe ruled correctly at sidebar that it was Mr. Ramirez that brought that up. Additionally, what came out during the trial, I think also substantiated part of that, the relevancy. Mr. Newsom, in particular, as opposed to the other two defendants, was, we had to address mid-trial that he was intimidating or threatening a witness for being a snitch. That's part of what's relevant also with that text message, because he talks about, if I don't get snitched on, I'm gonna bury that bitch in the backyard, talking about $8,000. So now we have, it's even more relevant. He's referring to someone as a snitch. At that point, Robert Allen, and I believe at least 2 or 3 of his co-defendants had already been arrested. He's again been in this trial berating someone for being a snitch who's testified against him. He referenced the money, which was important because they were looking for connections to this crime. And based on the chronology of it and the relevancy of the substance of it, I would argue that the ruling was correct in that no curative instruction would be needed or would assist the triers of fact at this point. And so I ask you to deny this motion.
Judge, I disagree with the state that simply stating that a search was conducted and what the law enforcement did during that search opens the door to the hearsay basis that was the issuance of a search warrant. I would point out that the testimony has been that my client introduced his own name into this case when he went back to that vehicle that had been abandoned, that was clearly used in this crime, and placed his name in it. So long before anyone else was a suspect in this case, or even before the individuals on the video had been identified, my client's name was involved in the case. So there was no need for the state to explain to the jury how the search may have been conducted, him placing himself in the vehicle hours after the vehicle was used to commit the crime. There's certainly enough in there for that warrant to issue. And I would simply ask the court to ask the jury to disregard it. The problem with it is the confrontation clause. The problem with it is that it's double hearsay. And the state, knowing this for all these years, did nothing to try to produce the text itself the way it came out. Detective Curcio said, well, I received the text. Well, not quite true. He didn't receive the text. He got it from a phone in another separate investigation and did not preserve it as evidence, did not list it as reciprocal discovery. A photograph allegedly of my client was attached to it. Where is that photograph? I don't understand how a detective could have that information and the state not realize it needs to be part of the discovery process for the defense to know it is in some way admissible. Other than that, it is double hearsay. It has no foundation, and I ask the court to ask the jurors to be instructed to disregard that. Because they violated my client's rights in front of me. It puts me in the position of having to challenge the veracity of Detective Curcio on that issue when, as you saw, I asked him very limited questions, basically applauded his police work in the case, and did nothing to impeach him. And to be able to say, well, he did a good job about all this, he was candid and honest about all the things they don't have against Mr. Newsom, we should disregard, ladies and gentlemen, without the help of the court's curative instruction, I would have to tell them to disregard what he said about that, and therefore challenge his credibility. And that's not what I choose to do in the defense, and I don't think I should have to. I think the case should rest or fall on admissible evidence, and I believe this was inadmissible evidence that can be cured with a curative instruction.
Thank you. All right, well, I made my initial ruling at the sidebar, and I'm sticking with that ruling. I know counsel actually was I think very good at not opening up doors that did not need to be opened and tiptoed around things I think in a very skillful manner. However, the issue of their digging up the backyard was brought out through counsel to the jury in opening. This is floating around out there. If the statement had been, yes, I killed the victim, yes, I received it, much more detailed, then I'm certain that the state would have put it out there in that form, and we would have had other, hearings on that That's not what it was. So, in looking at it, the basis of the ruling that I made at the time was, first of all, it's a statement purported to be by the defendant, so that takes it out of the hearsay limitation, although it is coming from another source, even where if an officer comes in and says, had him in the interview room, he told me this, that's his statement, that's coming in, even though it's coming in through the third person, you know, because there was a time when we didn't videotape all this stuff and we didn't have it in that way, or record it. So that would not in and of itself make it inadmissible because it's coming from a third party, the statement of the defendant. But more importantly, I'm looking at it as, you know, just going to the basics of what is and what isn't hearsay. It's got to be offered for the truth of the matter asserted. If they had found $8,000 in the yard, then clearly that statement would be offered for the truth of the matter asserted. But the truth of the matter asserted was, I buried some stuff there. Nothing was found. So it's not offered for that. It was merely offered to show why they're in his backyard digging up things. Because, you know, there's a question about, in this case or in any case, about whether or not the authorities have done a thorough investigation or what they're doing or what precipitates things. And yes, there were a lot of other matters involved in that text message which would not be proper in front of the jury, which were sufficient to get a search warrant, but which would be highly prejudicial to your client about, you know, exactly who it came from and what the purpose was. So I think the state, again, carefully tailored around that question to merely answer, why is it that you're getting a warrant in his house and digging up the backyard, because that doesn't come out of thin air. And what they offered was a statement talking about burying the thing. It did not specifically implicate this particular offense or that I got $15,000 from you know, killing Jose, and you know, it's not that detailed. And it merely gives reason behind why that warrant was procured and executed and that nothing was found there. And so it was based on that it's not hearsay because it wasn't offered for the truth. Additionally, it's a statement of the defendant, and therefore I found it to be admissible, and that not that you had opened the door through your direct questioning of Detective Curcio, but in bringing up the whole search, and this is just an explanation for that. So a curative telling them to disregard would be contrary to the way the court had ruled.
Would the court consider a curative based on what you just said, and that it was not introduced with the truth of the matter asserted, but merely to explain why they were digging in the backyard?
I would object, Judge. I mean, it looks like the state did something wrong when Your Honor is saying the exact opposite, that we didn't do anything wrong, and that it was within the court's ruling and proper to be able to bring this out.
I don't think that a curative is necessary at this time. I did, you know, at the time I made the ruling, suggest that you could suggest one to the court, and I would consider it. But again, I think it's admissible evidence under the reasoning set out by the court, and I don't know that a curative would be required. Certainly not one telling them to disregard. And at this point, after 20-some days of trial and many pieces of evidence, lots of statements out there, to pick one particular statement out and give them a curative at this point would highlight it more than it would cure anything, and I think it might be misconstrued. So your request is noted and preserved and overruled.
Yes, sir.
Thank you. And you styled it a request for mistrial as well, based, I guess, on cumulative effect, and I will also deny that, unless you want to be further heard.
Judge, I'll keep thinking. Maybe I can find a curative instruction that will some way be consistent with everything the court has just said. I am concerned about it becoming a highlight of the state's closing argument. I mean, it could easily...
It really should not be the highlight of their argument.
As an admission. You know, again, if it becomes that, we have absolutely no way to cross-examine it. had not received the text of it, had not received the photograph, can't challenge it in any fashion. It just came in through double hearsay, and let me keep thinking about it. But hopefully it doesn't become a feature of this case closed.
Very good. I let it in for a limited purpose. I think it should not be argued as a feature for another purpose.
Thank you, Judge.
All right. With that, shall we talk about instructions?
Why not?
Stage ready.
All right. No worries. We can take 5 minutes. We've been in session. Yeah. 5 minutes. And we're hoping that. Well, maybe not, but I mean, we gotta go through this stuff, but it'll be late.
Because I didn't hear you. Not yet.
So, sorry, we're not.
I know, but
Yeah.
really need to.
No.
I mean,
No, it has a future date, we deleted it.
no, because I made a mistake, so to speak. I'm probably gonna take mine. Headline. You're not on Zoom anymore, are you?
Only Friday, only calendar.
Okay, that's a good thing to know. We got the 28th already.
Yeah.
No, I'm just saying. I was just saying that I would have jumped on, I would have
Yeah.
jumped on Zoom. I'll get involved this Friday, because we can now.
Yeah, because I want to make sure.
Zoom is only Friday, calendar call things, everything else.
Oh.
Yeah, you didn't, if I got a text from you to show, I would What probably. is, what, 649? Yes, ma'am.
So some other guy's nervous now.
Oh, my God.
Right, something. What I do now?
All right, we all back?
Yes, Judge.
You ready to start discussing riveting instructions?
Yes, Judge.
State's ready.
Ready, Judge?
Okay. Any objection to the first page?
Nothing from the state.
None of the actions to go there. No, I'm sorry, Judge.
All right. Except that it says number 4 at the bottom. Get rid of the page.
No, did I address that in my email? I was gonna, I only paginated it for this conference.
Right, yeah.
For the final, draft, I'm gonna remove all the page numbers, and anything that's bracketed.
Right.
As well.
Yeah, I know. I'm kind of funny.
Oh, you're teasing me?
Because the certifications were placed at the front, but obviously they're going at the back.
Okay.
All right. Anyway, so first page is fine. It lists everybody, seems to be spelled right. All the case numbers are on there. Good. All right. Then the next page would be the introduction of final instructions.
Well, wait a second. I have three certificates.
Right. Put those at the back.
I'm just saying Trayvon is spelled wrong.
On the certificate?
Yes.
All right.
Oh, there's an extra V. I see that. I'll correct it.
But that's on the certificate. I'm just dealing with page 1.
I'll correct it.
Well, it should be page 1. Okay. We'll throw those to the back. We'll talk about them when we get there. All right. So then next is the introduction of final instructions. Do you any preference by the parties whether we keep you're going to get rid of the bracketed 3-1?
I intended to unless anybody wants to keep it.
Well, that's what I was going to say. I mean, they don't really need to know where the instruction comes from, but
I agree.
we're taking that out. Just it'll say introduction to final instructions.
That's fine, Judge.
Okay, and then that's an easy instruction. All right. Then next would be the 3-2 statement of the charge.
Judge, I did have an issue with this. The standard instruction does not, each of these has count 1 of the indictment. The standard instruction does not have that language of the indictment. I would ask that just the phrase of the indictment be removed from each sentence.
Going. Agreed.
I don't have a position on it.
All right.
That's
Yeah,
fine.
we can take that out.
So
So that'll
you say-
read
Has been
accused in count 1 of the crime of murder in the first degree and in count 2 of the crime of armed robbery.
Okay.
All right, next we would have introduction to homicide. Now, I don't have any problem reading this entire instruction 3 times. Is that what the parties wish?
I guess I understand why the court might not want to do that. It does get tricky if the court tries to put in all 3 names.
I'm just talking about on the introduction section, because
Not even really being asserted justifiable or excusable by any court.
there's no names in there. So
I would agree with
it
you.
could be read, introduction to homicide. In this case, Dietrich Williams is accused of murder in the first degree and armed robbery is charged in the indictment. In this case, Michael Boatwright has been accused of murder in the first degree and armed robbery as charged in the indictment. And in this case, Trayvon Newsom has been accused of murder in the first degree and armed robbery as charged in the indictment. And then I just go through and read the rest of the instruction.
Well, then have,
Now, when we get to the individual counts, I think it is probably important to do them individually. This is just an introduction to homicide generally. But again, if anyone objects, I'm happy to read it 3 times. But I don't know how happy the jury is to listen to the exact same thing 3 times.
On behalf of Mr. Newsom, Judge, we have no objection to reading it once, using all three names at the forefront of it, so that it's clear that three times the same. And if we were arguing excusable, justifiable, I might feel differently, but nobody's actually arguing that. So
George,
it just has to be given.
I think we're gonna be the outlier. That's a good word. Thank you. I think we are gonna object.
Okay, I'll just read it 3 times.
As to there are a couple of parts of it that deviate from the standard instruction. On the third sentence, where it says a killing that is excusable, the standard instruction reads, however, a killing that was excusable or was committed by the justifiable use of deadly force is lawful. We request that we object to the language as is and request that it be word for word with the standard instruction.
Okay.
All right, change that on all 3.
And then the dangerous weapon definition also does not track the standard instruction. It should read, a dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and instruction. And that's what we are requesting.
1 second. All right, let's change it to track exactly from the Supreme Court instruction on,
So it's the sentence starting with the italics, in quotation, dangerous weapon?
Correct.
Okay.
yeah, as it reads in the Supreme Court instruction, a dangerous weapon is any object. So,
Okay, no problem.
That's it. I have no further objections or requests.
Okay, so we'll make those changes, and since I'm doing it 3 times, you make the same changes on all 3.
Okay.
I'm hopeful that once you take out that 7-1 there, that last sentence will fit on the page. It should. But if you need to adjust the margins, if you can make it a 1-pager, it's just easier.
Okay.
All right. Then next, we have 7-2, first-degree murder.
Judge, I have 2 objections. One goes to the final paragraph. The last sentence says, "In the conduct of the defendant, convinced you beyond a reasonable doubt." The the standard instruction is in the context of the accused, request that the word accused be substituted for the word defendant. So that is what is in the standard instruction.
No objection, Judge. I can change it in all three. Doesn't matter.
Okay, that's in the last paragraph, correct?
Correct.
All right.
And then,
Go ahead.
My second objection, the court has requested, or the state has requested the standard, a special instruction, which is in italicized. They've requested this language: premeditation can be inferred from such evidence as the nature of the weapon used, the manner in which the murder was committed, and the nature and manner of the wounds inflicted. We object to the inclusion of that special instruction. In order for a special instruction to be included in the jury instructions, 3 prongs must be met. 1, it must be supported by the evidence. 2, the standard instruction must not adequately cover, in this case, the state's theory. And 3, it must be a correct statement of the law and not misleading or confusing. We object on both the first and the second prong. We obviously moved for judgment of acquittal on premeditation. It's our belief that there is no evidence of premeditation. The state has failed to present a prima facie case of premeditation, and as such, the special requested instruction is not supported by the evidence. Second, even if it were, this is the standard instruction that has been promulgated by the Florida Supreme Court. It adequately covers the state's theory of premeditation, and this additional, language isn't needed because it's already included within the standard instruction. So we object.
It's not included in the standard instruction. Additionally, Your Honor ruled against the defense saying that there was no prima facie evidence that there was premeditation. My exact argument was, by the nature of the weapon, which was a .22 caliber rifle used in this case, also the act of killing, pointing a loaded .22 caliber rifle at the victim's head and upper neck area, and then shooting the victim 3 times, that the nature of such evidence and the weapon used, the manner in which the murder was committed, that the wounds were inflicted, that premeditation can be argued based on that. That is the exact argument that the state made at the JOA and directed verdict stages. Additionally, reading the standard instruction for first-degree murder, it does not cover that. And I imagine, I don't know what the defense is going to say, but I imagine they're going to argue that the state did not meet its burden for premeditation. And I would like to be able to argue and have the law correctly reflect as it does, based on Fennell versus State, cited at 959, Southern 2nd, 810, which is a 4th DCA case, and Perry versus State, cited at 801, Southern 2nd, 78, which is a Florida Supreme Court case, that we should be able to argue that the jury should be properly instructed on that so that they know that that is a proper argument.
Let me hear from counsel for Mr. Williams' concerns.
No,
Judge, if it's a special, I don't know that, including it there in this, the first-degree murder is the appropriate place for it. I don't think it's necessary under the criteria cited by Mr. Kimmock in terms of helping the jury understand. So I would object to this language.
All right, well, I mean, it's not a special as a separate special, but.
I make no further objection beyond the objection that came up in for the record.
Okay, so you're adopting his argument?
Yes, sorry.
Okay, no worries. I do find it to be a correct statement of the law. In fact, when we were discussing the JOA, and I think the state may have mentioned some things, but I essentially quoted this language out of cases, not the 2 that are cited here, but it's just, it runs through an overwhelming amount of the appellate cases dealing with first-degree premeditated cases. That sentence or that blind. I think the jury instructions are meant to help guide the jury to make a proper finding in accord with the law. And it is a correct statement of the law, which I do not think is covered by the language that is prepared, and I am prepared to add that.
Judge, if I may, I'm reading from Fennel versus State 959 Southern 2nd 810. And the reason is because the state has included only the prongs of premeditation that assist them. There are a number of other prongs in premeditation that...
You mean the prior difficulties and the others?
Correct.
It's a longer statement. If you wish, we can put the whole thing in.
I mean, maintaining our objection to having it in there anyways.
But if it has to come in, you want it with the whole site.
Correct. So,
I will agree with that and have it so that it reads the full string again, which is oft-quoted and is in all sorts of instructions. Premeditation can be inferred from such evidence as, and I think it starts out with nature of the weapon used, but then read it, it's like prior difficulties.
Yeah, the premeditation may be inferred from the nature of the weapon used, the presence or absence of adequate provocation, previous difficulties between the parties, the manner in which the homicide was committed, and the nature and manner of the wound.
Right, so it misses those two things, but that's a correct statement of the law, so if we're going to put it in there, let's use the entire quote.
Okay.
Not as a quote, and again, I know you indicated earlier that obviously the case site references will be removed.
Correct.
Okay, very good. Any other changes on this one?
That'll be after Mr. Newsom now.
No, Judge. No, Judge.
And again, even though it does not mention any of the defendants individually by name in the instruction, I will read it 3 times. I will say, and how I will do that is, after reading the prior instruction, then I will say, here's the instruction on first-degree murder with respect to Mr. Boatwright, with respect to Mr. Williams.
It says that the names are in there, in count 2,
From.
Oh, okay.
or element 2. The death was caused.
Oh, okay, okay. Yeah, all right, I see it. All right, very good. All right, then we have the felony murder. By the way, I mean, if you want, we can have our discussion on that. The state has provided a number of cases on point on that. The defense hasn't presented me with any that say that they're not allowed to argue either theory, even if only premeditated was charged in the indictment.
Yes, Judge, I can see that Florida law permits the state to do it. We nevertheless object as to the constitutional due process rights of Mr. Boatwright to be advised of the full charges of him.
All right, and again, in addition to the cases that the state provided me with, which were Crane versus State at 894 Southern 2nd 59, 2004 Florida Supreme Court case. Parker versus State, 904 Southern 2nd 370, 2005 Florida Supreme Court case. Mansfield, 911 Southern 2nd 1160, 2005, again, a Florida Supreme Court case. The court also would cite to Weatherspoon, Weatherspoon, v. State at 214 Southern 3rd 578. That's Florida Supreme Court 2017. Dessaur, Dessaure versus State at 55 Southern 3rd 478. Florida Supreme Court 2010, and Stanley versus State 57 Southern 3rd 944, that's out of 4th DCA 2011, all holding that it is sufficient notice in an indictment if you charge premeditated first-degree murder, that the state may also argue felony murder, as long as there is some where in there where the felony is either charged or explained, and in this case, since the qualifying felony is robbery, and that is actually a charge offense, and since the jury will be fully instructed on that charge and element, it's fine. But I thank counsel for conceding on that, although objecting, I guess, in hope of future changes.
Judge, could you please just repeat the Decessor site one last time? I didn't catch that one.
55 Southern 3rd, 478, that's Florida Supreme Court, 2010.
Thank you.
Witherspoon is probably your best bet, because that's a 17 case, was
Right.
the most recent one I can find.
Yeah, I got that site. Thank you, Judge.
All right, so looking at felony murder. Again, it enumerates robbery. It's got the definition of robbery.
With regards to all three, the last sentence is only necessary under the standard instruction if the accused is a juvenile, and that's because the mandatory minimums kick in.
You're talking about to be a principal?
No. If you find Dedrick Williams guilty of first-degree felony murder, you must also determine whether the state proved beyond a reasonable doubt that he actually killed John J. Onfroy. I would object to that. It's not part of the standard instruction for a non-juvenile, nor is there, especially Mr. Williams, nor is there an interrogatory with regards to that. The standard instruction has that language. It says, if the defendant was a juvenile at the time of the crime alleged.
I'm pulling it up. Hang on a second.
I'm looking.
I don't have an objection to removing it, Judge.
Yeah, that's really a result of, I think, Graham Miller, right?
The new the statute that was adopted by the legislature in response to that.
Yeah, so we don't need that last sentence.
And then I assume we're gonna take out the, highlighted.
That's
Yes.
in my email. That's throughout the whole document, the highlighted and bracketed stuff. I only left that in case there was any questions regarding the interlocking counts.
All right, and so again, it's the same instruction for all three with the exception of their names are in each one.
Yes, Judge, it is in each one.
Right, that's what I'm
Yeah.
saying. The instructions are the same on all three of those, so.
Yes,
So we'll be taking out that last sentence in all three.
yes.
All right, then next I would read the 312B legally interlocking counts.
I have no objection.
No objection. No objection.
Count one. Give me a second.
I was gonna say, Judge, this one is actually in fact language exactly as I got it from the Florida Supreme Court.
Yeah, it just. I'm not sure about the 312 because is it a truly inconsistent verdict if the jury were to find that there was homicide without a robbery? On the other hand, could they find a robbery without a homicide? The only time they're actually linked is under felony murder, but not under the premeditated. If you have premeditated murder, it is not necessarily legally interlocking with robbery, and certainly they could be acquitted of the murder and still found guilty of the robbery, where this says if you don't find them guilty of the murder, you can't find them guilty of the robbery. I don't think that's a correct statement.
So you're saying in the event that the state had indicted them as saying no premeditation and it was only felony murder, with the enumerated felony being robbery?
Then you would have to say that you cannot find murder unless you find robbery.
Right.
Right?
But because
But
it's
you
also
could find robbery without finding the murder. And this says, if you find that the crime charged in count one has been proven, you must then. The second paragraph is correct. It's the first one. To adequately have this be a proper instruction, which they should be instructed on, I think it should say counts 1 and 2 are linked and that the crime charged in count 1, first degree felony murder, robbery is an essential element. Because it's not premeditated, but it is the felony murder. If it was only charged as felony murder, they're legally interlocking counts.
Okay.
So we're just adding.
And then, well, no, but actually, if you find the crime in count 1 has not been proven beyond reasonable doubt, you must find the defendant not guilty on both counts 1 and 2 is not correct. They can legally find, it's not inconsistent for them to find a robbery without finding a murder. If they believe, for example, that they aren't principals or only on robbery. So I'm not sure that the legally interlocking counts instruction applies. If it does at all, it is only with respect to count 1 under a felony murder theory, not under a premeditated theory, and it does not apply to the robberies standing by themselves. Am I wrong?
No, I understand what you're saying.
I guess the state has requested that the instruction near the verdict form that some jurors can find them guilty of felony murder, some can find them guilty of premeditated murder. They don't all have to agree. We're going to argue about it. That's part of the standard instruction. We're going to have a discussion about that later. But I guess I would request that there be some language that says that, look, if you don't believe that they committed felony murder, then you must acquit them on the armed robbery. And so I think that I would request that we keep it. I don't disagree with the court in specifying it to felony murder. So we can say, felony murder and count 2 are linked, and that the crimes charged, and that the crime of felony murder, robbery is an essential element of the crime charged in count 2 armed robbery. You should first consider the evidence applicable to felony murder. If you find the crime of felony murder has not been proved beyond a reasonable doubt, you must find the defendant not guilty of robbery.
But it doesn't address the other areas that Your Honor has said, which is, and first of all, they don't have to elect on a verdict form or ever have to state when they're polled or in court which theory they elected. So it's a misstatement of the law to say it that way, to say, well, if you find this, then you must find that. Because one of them could find that it's felony murder, guilty of felony murder, and the other 11 could find that it's premeditated, and they never have to say that, and they never have to indicate why, as long as they say guilty of first-degree murder. So based on the concerns that Your Honor has raised, I would argue that then we remove the legally interlocking counts instruction, because it's more confusing than it is assisting them and aiding them with what the law states. It becomes a misstatement of the law.
True and consistent verdicts are those which an acquittal on one count negates a necessary element for conviction on the other count. So only with respect to felony murder, but not to the robbery. And this, wow.
I'd also point out that I'm looking at the comments under, I guess these were the legislative comments under the legally interlocking counts, and technically, we have not charged felony murder. because it says, and if we're reading this as black letter law, legally interlocking crimes are charged when the crime charged in one count of the information or indictment is an essential element. What the defendants have been charged with, technically, is first-degree murder. We're allowed to argue the alternate theory, but it's not charged. So technically, I don't think that it would apply, just because reading this as plain black letter, it's not something that we charged.
Right. I don't think legally interlocking counts applies because it's misleading in that the way it ties them together. Specifically, as it's read, it talks about if you don't find count one, you can't find count two, which is just not the case here. Now, what I also don't like is, and really this should be read after, behind the verdict forms and not at this point, which is why it's the 312. What I would say is what we have, what you printed out after the verdict forms, I'm jumping way ahead, guys, is the 312C, multiple counts, multiple defendants. But the way that reads, it says, a separate crime is charged against each defendant, each count of the indictment. Defendants have been tried together, however, charges against each defendant, the evidence applicable to him must be considered separately. That really addresses the fact that a finding of guilty as to one of the defendants must not affect the verdict as to the other defendant. And it says, or other crimes charged, but the single defendant, multiple counts or informations, says the finding of guilty or not guilty as to one crime must not affect the verdict as to the other crimes charged. I would propose that we tailor that 312A, take out the thing that says single defendant, just multiple counts, and say a separate crime is charged in each count of the indictment, and although they've been tried together, each crime, the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. And then follow that up with separate crimes are charged against each defendant. So two separate instructions instead of trying to have it as one. Because they should be instructed that not only can they find that their finding of guilty on one count doesn't force a finding on another count. And secondly, the 312C is their finding guilty as to one defendant shouldn't affect their finding as to another defendant.
Just so that I'm understanding, you want me to leave 312C in, but
Yes.
add before that, just before that, 312A?
Yes, although
Okay.
just take out the wording that says single defendant. So in other words, they get one instruction saying that a decision as to one count should not affect their decision as to another count. They've been tried together, the counts, but their verdict must be to each count individually. And then the 312C says the defendants have been tried together, but their verdict says to each defendant shouldn't affect the other.
So it'll just read, for the caption,
For the 312A,
Yeah.
multiple counts.
okay, got it.
Can I hear from the defense on that?
Because I object, I understand what the court is saying as far as, premeditation, they can find a premeditation. Felony murder and armed robbery are legally interlocking accounts. The state is proceeding under, in part, a theory of felony murder.
Hold on a second. Moving up, put interlocking counts aside for a second. I'm just talking about instruction 312C, multiple counts, multiple defendants. Well, I think does not adequately tell them. I would like it separated that counts are distinctive and defendants are distinctive. I think that protects the defendants. And And so instead of just reading the multiple counts, multiple defendants, because that really just talks about finding as to one defendant, but it doesn't talk about finding as to one count. Except the last wording, other crimes charged, but it really doesn't adequately address it in the same way that 312A does.
So, I don't generally have a objection to the inclusion of the language in 312A as long as, but I am nevertheless requesting that last phrase be included, except as explained in the instructions for legally interlocking counts, and requesting that legally interlocking counts be included, tailored to felony murder and armed robbery, because again, felony murder and robbery are legally interlocking.
But only with respect to count one, not with respect to count two. So that whole instruction would need to be refitted, because you could find not guilty of felony murder, then still find him guilty of robbery. But the way the instruction reads, it says if you find him not guilty of felony murder, you must find him not guilty of robbery, and that is incorrect.
So the sentence of that, of 3.12A will end with, the last sentence will end with, at charge, the bracketed language will be removed since we're not including the interlocking counts instruction, correct?
At this point.
Okay.
And then on the 312C, it would be as you have it, but because we're calling the 312A multiple counts, 312C could just be multiple defendants, so that they understand that we're covering both subjects. But again, those instructions really go after I read the verdict forms.
Okay, I'll place it
All right. Now,
there.
with respect to, we need to solve this legally interlocking counts. I don't think it applies, although it sort of applies to count one under a felony murder theory, but not under a premeditated theory, and it does not apply to count two. Count two does not depend on count one. But felony murder in count one does depend on count two. In other words, you can't have felony murder without having the robbery. You can't have a robbery without having the felony murder, and you can have premeditated murder. Those are not interlocking. The only thing that's interlocking is felony murder predicated on a robbery and a robbery.
Correct. But that also supposes that they would have to elect, which they do not have to based on all the case law, which theory they're finding the defendant guilty on. So if we could be in a situation where all 12 find the defendants guilty of first-degree premeditated murder, never have to, because the law says they don't have to elect which theory, and it's not interlocking counts.
I don't know how we can fix this. How we're going to fix this is we will include one second. Yeah, no, it's unnecessary. The felony murder statute itself, as an element of it, says commission of a robbery and gives the definition of a robbery. So the fact that it is a necessary precedent is already in the felony murder statute. The illegally interlocking counts is just an incorrect statement of law as it exists to count 1 and 2.
Okay.
So, over objection, if there still is any.
Yes,
I'm not,
yes, Judge.
okay, I'm not going to read 312D at all, but I will ask again at the appropriate place to have the multiple defendants and the multiple counts broken into 2 instructions.
Yes, I have that.
Which we discussed already.
I have that notated.
Okay. Now, all right, so getting back to the order of things, we've just gotten done reading premeditated murder and then 7-3 felony murder, first read as it is. Then I would read
Page 21, 3.4.
see again, this is sort of an order thing. Usually, where's my armed robbery instruction? Because you have a robbery one in there. Am I missing it?
So Judge, when I looked on the Florida Supreme Court criminal one, it had it under 15.1. And then it had also the enhancer under, I believe, 775.087 regarding
Yeah, there's no
firearms.
separate instruction, it's all part of the 15-1.
It's in there.
It's in there, Judge, it's after the homicide instructions.
No, in the robbery 15.1 at the bottom, it discusses the firearm.
Right, that's what I say, it's all part of it, so. Hopefully you guys can understand how I'm saying this. But what I usually prefer to do is read the charged offenses before I read 3-4, even where there's multiple counts.
Okay.
So I would, right after reading the murder 1 premeditated and murder 1 felony murder, those are the count 1, then I would say with respect to count 2, robbery, then I would read the robbery instructions. So
Okay.
let's pull those up at this point.
So
Instead
those
of
are-
reading all the lessers for murder and then reading robbery, we do lessers after we read all preliminary charges.
Understood, so it's gonna go premeditated murder, felony murder,
Robbery.
robbery,
Then 3,
then,
4
okay,
lessers.
that's fine.
We'll
All
do it,
right.
I would ask that.
So let's look at 15-1 robbery.
So,
Go ahead.
here's the only wrinkle with that. So, in the order of how Your Honor is stating to read it.
I'll have to read it twice.
Oh, okay, so if you're gonna read it twice, because then it brings the bull in the aggravation with the firearm. Got it. So I'll add it twice.
Okay.
Understood.
So, well, we'll get to that part after. So once again, we just read felony murder. Now, next will be robbery. And even though it doesn't say it on here, usually I will, as I'm reading it, say it now. With respect to count 2, robbery. And so I define it there.
Okay.
Any objections as to the way the robbery instruction appears?
Not on behalf of Mr. Doherty.
Not on behalf of Mr. Newsom.
No, Judge.
Okay, so again, I'll read that once each for each defendant. Then we get to the 3-4 when there are lessers. First question is anyone asking for lessers?
Yes,
Yes, Your Honor.
Okay, well,
the state's asking for the category 1 lessers for homicide.
so murder 2 and man,
Yes.
and from armed robbery to robbery.
Well,
Yes, Your Honor.
Judge, we are,
okay. I wasn't originally asking for it, but if they are, I mean, it goes
If one
in
side
there.
asks, we all get it.
on behalf of Mr. Boatwright, we're asking for robbery. We're also asking for category 1 lessers and petty theft of assault.
Join.
So, assault was not charged.
It is, I'm looking at the indictment right now.
It was an or.
By the use of force, violence, assault, or putting the said jaze on foot in fear. Once you have the word assault in there, it's correct.
You're asking for petty theft, robbery, and assault?
Yes.
Like, my only argument, and objection is that it says or, but otherwise I'm not, if Mr., on behalf of Mr. Boatwright, if they want it, then so be it. I'm not gonna stand up and down objecting to that.
Okay. You guys want to take that?
Well, when you say you guys, Mr. Boatwright's the only one.
I'm asking.
Oh, okay.
If someone asks for it, they're going to get it.
Okay.
We'll join on behalf of Mr. Newsom, Judge. I don't think we can read it differently.
All right, so the Cat 1 lessers.
And so that I don't have to do this twice, is Mr. Williams asking for it? Because right now, the only ones I have, you are?
Yeah.
Okay, so all three defendants are asking for the cat one? Okay. Okay,
So robbery, petty theft, and assault.
okay.
Okay, so you'll add those two in there, otherwise the instruction would be correct. Lessers for murder in the first degree or murder in the second degree in man. Lessers for armed robbery is robbery, petty theft, and assault. Then I will read murder 2.
That, Mr. Boatwright, no objection to the murder to instruction.
Agreed on behalf of Mr. Newsom.
Agreed.
Then I will read the man instruction. Any objections?
No objection on behalf of Mr. Boatwright.
None on behalf of Mr. Newsom.
None.
Then I will read the aggravation by carrying a firearm to Mr. Boatwright and Mr. Newsom, but not Mr. Williams. Any objection to the way that is?
No objection.
No objection.
No objection.
Okay. Then I will read the robbery, well, actually, before I read the aggravation of crime, after I read manslaughter, then I need the robbery instruction 3 times again, because but this time, because it's just robbery, you'll take out the other portions of it that deal with the firearm. You understand?
I think so.
Well, because I'm reading robbery as it's the same instruction whether it's the LIO or the original, but the original one has carried a firearm, you should find him guilty of robbery with a firearm. Firearm means all that. For the simple robbery, we don't need that. So you'll take out the last 3 paragraphs the second time I read it. Yes?
Okay.
Agreed.
Defense agree?
Yes, Your Honor.
Because otherwise it doesn't look like an LIO. Then you'll add in petty theft, the 14-1 instruction, and then the assault, the 8-1 instruction.
Okay.
Then I will read the 3.3a aggravators. Then I will read the 3.5a principal instruction. Any objection as it's?
No, yeah, principal orders.
No, Your Honor.
Where are we at? The aggravation of crime?
Now we're way beyond you.
I'm sorry, can you repeat that again?
So we did the aggravation after that, and then I will read 3.5a principles,
Okay.
which there's no objection as written. Then we get to 3.7, plea of not guilty, reasonable doubt, burden of proof. Any objection as that is set out?
No objection.
No objection. No.
Then I will read 3.9. The only one I have question about would be 10. I don't think there's been any general reputation evidence.
I agree. I added all of them just that
Right,
way.
we start,
Right.
all the others seem to apply. Offense? There was no general reputation evidence presented.
Judge, Mr. Allen volunteered, I think during the state's questioning, that he did fraud. That was a way that he, that was something that he was doing at that time. I think that's enough to include the number 10, and we would request that it remain in, object to it be taken out.
Judge, I was asked to number 9. That was asked to his felony convictions, and then there was questions regarding that. What was he convicted of? How many times? So that's number 9. There was no testimony about any of the witnesses having a general reputation for dishonesty or truthfulness. It just wasn't.
He brought, Alan brought it up when he was explaining why he had multiple phones. He brought it.
That is not
That's
satisfying.
not general reputation. General reputation is how people in the community feel about you. And no one in the community came in and said, I know this Alan character. I wouldn't believe him if he told me he was standing in front of me when he was standing in front of me. Okay? That's what that instruction really goes to, is general reputation, not his self-assumed reputation, any more than if he got on the stand and said, I am the most truthful, law-abiding, trustworthy person you will ever know, he would not get a trustworthy instruction. Because that's not general reputation.
He did admit that he lied on various occasions.
I understand, but general reputation is how do other people view him?
Got it.
And there are a bunch of specific rules in the evidence on how you get general reputation evidence in, when it becomes, and this instruction deals with when that evidence has come before the court. That hasn't. All his other statements, they're fair argument, they're out there, but that's not part of this instruction. And you do have the convicted of felony or misdemeanor, whatever. So we'll take out 10. Are you guys still objecting to that? Just for the record purposes?
Yes.
Yes, Judge.
All right, over objection. I'm taking out 10. And otherwise,
Judge, we are requesting the standard instruction on accomplices and informants.
What's the number?
It's under 3.9, the same one that we're on. It's just been taken out. If you go to the 3.9 standard instruction, it's the paragraph under expert witnesses. It's the same paragraph that I referred to during Fort Otter.
yes.
Otherwise, I have no other objections.
Yeah, accomplices and informants. How do you want it tailored? Because there's brackets there.
Yeah. For example, a witness who claims to have helped the defendant commit a crime
That would apply.
or hopes to gain more favorable treatment in his or her own case.
That would apply. The middle one does not seem to apply because he certainly was not given immunity.
I agree.
Agreed.
Okay, so just add that in after expert witness, but before witness talking to the lawyer.
Okay, hold on, I'm gonna try to add it in right now. Just wait.
No problem.
Okay, you wanted it added where, Judge?
It comes after expert witnesses, which are, if you're looking at that, it's on the second page of it.
After expert witnesses, okay?
But before it's entirely proper. So it just fits in between there.
Okay?
Everyone agree on that?
Yes,
So you
sir.
said there was a middle part that should be taken out?
Where it says, the parenthetical has been promised immunity for prosecution.
Third line.
Oh, okay, there we go.
The other two parentheticals apply, so you leave them.
Okay.
But
got it.
you're gonna have to put like an or an and in between them, yes? So, for
Okay.
example, a witness who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment in his or her own case. maybe.
Okay, got it.
For what it's worth, I'm guessing that George remembers when expert witnesses were a separate instruction where the fact, a witness talking to a lawyer should not be discredited used to be part of 310. Just for my own edification, the reason it changed, I wrote the change. I said, why do we have witness should not be discredited talking to attorneys as part of your rule for deliberation as opposed to weighing credibility of witnesses? It doesn't make sense, and we should move this. So I proposed this change. This is like my one permanent thing that's happened was I changed 3.9 for better or for worse.
You
But
do something about reasonable doubt too, but it's so maddening.
yeah, I'd like to, but that's been tried before too. You probably remember that as well.
Oh, yeah.
Yeah, didn't go well.
It's gonna get worse, I think, if I remember the legislature.
The feds have a nice instruction on it. In any event, so that's 3.9. Then 3.9A, defendant not testifying. We're good with that?
Yep.
No objection this
No
time,
objection.
Mr. Kimball?
No objection. No objection.
39B is Peter Williams' statement.
I just saw two typos. And number one, whether when Dedrick Williams made the statement, he had been threatened in order to get him to make it.
He to make it, yeah, okay.
In order to get him to make it. And
Where are
two,
you? I'm sorry, where are you?
39B,
Right under one?
yeah,
Oh, okay.
says whether he had been threatened in order to get he to make it, it should be him.
Okay,
And the same thing in number two, whether anyone had promised him anything.
got it.
good catch. Thank you.
Old English teacher.
All right, anything, any objections?
Looking for, no, Your Honor.
All right, 39C, eyewitness identification.
No objection. No objection, no objection.
Would like it as written. Yes, everyone? All agreed?
Yes.
State?
I'm sorry, Judge. Can you please repeat that?
39C,
Yes, I have no
everybody's agreed as
objection.
written.
I have no objection. And he's the only one that there's a statement as well. She was bringing to my attention that there's only one for 39B.
Right, well, because nobody else made a
Correct,
statement.
it's correct. There's only one statement. Okay.
Then we have 310 rules for deliberation. Here's correct. Everyone agree?
Yes.
Yes, agree. Just to go back to 3.9B, defendant statements. I accept the instruction not waiving, we had objected to Mr. Williams' statement being introduced at all, to the content of it. I'm certainly not waiving that objection.
Understood.
Anyway,
The agreeing to a instruction on evidence that you've objected to doesn't waive your objection to it, but I'm only asking here if you agree with the language for the instruction. So,
Yes, Judge.
noted. All right, so again, 310, we're all good with that. 311 is the cautionary instruction. 312, verdict.
So I'll remove the italicized highlighted language, because I wasn't sure how the court was gonna rule when I prepared this, so I'll go ahead and remove that.
Judge, because we objected, we obviously moved for JOA for meditation, continue that, and because of that, we also object to this language, the last paragraph.
Understood. Noting the court overruling that, do you agree that in the position that you're at, that this is the proper word?
Yes, it's part of the standard instruction.
Everyone else agree?
I have no further objection, Your Honor.
Join on behalf of Mr. Wilson, giving it this language.
Thank you. All right. Then we come to the verdict forms themselves. On Mr. Williams, count 1 and 2. They appear proper.
I think, we would just need the petty theft.
Yeah.
Assuming, I think Mr. Williams asked for that, we would need the petty theft and the assault option.
The LIOs.
On all of them.
The LIOs under count 2.
Okay.
Beyond that, no further objection.
Then, for Mr. Boatwright, there are the interrogatories. Count 1 appears correct. Count 2, we would need the LIOs.
Okay.
Interrogatories appear correct. Do you agree, Mr. Kimmock?
Yes.
All right, and then for Mr. Newsom, which one did you say had a typo?
Trade on has a typo, but in the certificate, not on the.
Oh, okay, not on the vertical. All right, so hold your thought on that. Count one appears correct, one interrogatory. Count two appears correct with one interrogatory plus LIOs.
Judge, just the year is wrong. On count two?
No, count one.
For Michael Bolton. For Michael Bolton, count
Okay.
two?
That was
Okay.
a good catch.
Well, English teacher, not math, right? All right. Then we get to the, after I read those instructions, I'll do the multiple counts instruction as we talked about, and I'll do the multiple defendants instruction as we talked about.
Okay.
And again, I'm not giving the 312D interlocking counts over whatever objection still remains. Then we will do 313, submitting the case to the jury. The exhibits will be sent into the jury room. On page 2, you have the options there. The exhibits are going to be sent into the jury room with you when you begin to deliberate, with 2 exceptions. I don't know that we need to have them actually, the exceptions typed out here unless you want it, but I'm going to just tell them I'm not allowing live ammunition to go back with the firearm. And there was the phone dump. And so I will tell them that the firearm will go back with them, please do not remove it from the box. Also, but that the live rounds are going to remain up here. If they wish to view them, they should just buzz and ask to look at them. And that the entirety of the phone extractions are in evidence, but I'm not sending them back. If there's a specific portion you wish to look at, please let us know in writing and we will queue it up because it'll take, you won't find it on your own. Fair enough?
That's fair. That's fair. So for that sentence or that paragraph, it'll just say these exhibits will be sent to the jury room with you when you begin to deliberate with 2 exceptions, period, and then you're gonna add
And then I'll
that.
explain them. Are you okay with me just explaining them like I did without having it written out?
Like you just, yes.
Yes, fine.
That's fine, and then I remove the second
Yes.
sentence?
Yes.
If you wish to see the exhibit, okay. All right, got it.
All right, rest of that looks good. And then we have our certificates.
I have it notated to correct.
Yeah, it's just
To correct that.
spelling error, okay. All right, any other objections, additions, or deletions other than already discussed?
Yes, so with the manslaughter, which is 7.7, I had that the standard instruction has, well, first of all, I have it as 3 and 4. So I need to correct the
So 1 and 2.
Yeah, I need to correct that. But then also the,
Yeah, you have it 3, 4, 5, 6.
the next instruction, I don't know why, but I left it out. The standard part needs to say, every person has a duty to act reasonably towards others if there is a
The regular
violation.
negligence instruction?
Yes.
Yeah.
And there was also an instruction to read on justifiable and excusable homicide in the absence of an express concession by the defendants that the homicide was not excusable or justified. So if they're not stating that under State v. Spencer, then the court would have to read that portion of justifiable and excusable homicide. The instruction says that it would be fundamental error not to instruct on that. But they have to, I guess they have to be colloquy regarding that. that they are not, that there's an express concession that the
Does it
homicide.
have to be read as part of 7.7, or is the fact that it's read in introduction to homicide? Because they're already instructed in introduction to homicide. So what is everyone's position on whether you want me to re-instruct as part of the LIO manslaughter?
Well, it says it in the bracketed part that the explanations of justifiable homicide, excusable homicide are in instruction 7.1. So that, I guess what Your Honor is asking would qualify under that.
Weird, I may have to go there.
Does it say in there that they are already in there and you have to read them again? Or does it say that if they're already been read in 7.1, we're okay?
I think it's more the latter, but it doesn't say it that way. It just says the explanations of justifiable homicide and excusable homicide are in instruction 7.1, introduction to homicide. So it's included in that. So Your Honor's going to be reading it, so.
Right, they're already instructed on that.
Correct.
I think we're okay. Any objection to that format?
On behalf of Mr. Newsom, no objection, read it once, doesn't need to be read twice. No objection. Agreed, no objection.
Okay.
Okay, so then the language then, every person has a duty to reasonably act towards others, is going in along with in order to convict by manslaughter by act.
You put it before, right after the 1 and 2, then you read the, if I'm remembering correctly, then the next thing that comes is the definition of regular negligence, and then it's followed with that sentence that you have there: the defendant cannot be guilty of manslaughter by committing a merely negligent act. Oh, yeah, and actually, to answer the other question, we can do this. Are you following me, Pastor?
I am. I'm looking on the standard instruction, Judge, and I'm trying to follow along.
I'm going from memory, but it
I have it. Okay. May I come up, Judge? I can show you.
no, I can pull it from this.
Okay, because I have it here. It says, right after the elements, it says every person has a duty to act reasonably towards others. There's that paragraph. Then the next paragraph is, in order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had intent to cause death.
Yeah.
And then the only other instructions after that are, if applicable. And that's regarding culpable negligence, which we
Right.
don't have here, and to procure. And then that's it. Then it goes into the lessers. So I'll have to, based on that, and what I can do, just because this is a big change, I can change it right now and show everybody to see if that comports with.
The other thing that we could do, just to see, it's exactly what I was going to tell you to do.
Okay.
Where it says in that sentence, defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable, or was either justifiable or an excusable homicide. Justifiable or excusable homicide. Well, that's English, man. That's poor grammar.
So,
But it in the instruction there, it says, as I have previously instructed you. So throw that sentence in there. That's what I was going to suggest doing anyway.
where, Judge? That part you lost.
Do you have the manslaughter instruction that you had before? That first sentence after paragraph 1 and 2, the one that
Okay.
says the defendant cannot be guilty,
Okay,
all right? It ends in excusable homicide, period. The way it is in the instruction and to make the references, instead of period, make it excusable homicide, comma, as I have previously instructed you.
okay,
There you go. And then you add in the other stuff.
The other two paragraphs
Yes.
will go right after that?
Yes.
And so you want me to leave in the killing of a human being is justifiable, homicide, and lawful?
Yes.
Okay. Got it.
Does everyone understand what we just did? All right.
I will-
Well, I mean,
I will
what we're
once I see
going
it.
to do anyway is now that we've made all the changes, once you have put them all in proper format, why don't we break for an hour, you guys go have lunch or whatever, come back with a final copy and we'll run through it to make sure it comports with everything, yes?
Okay, that's fine.
Couple of quick matters, Judge, if I might. I believe during the trial you mentioned that you would reread an instruction at the end based on what you crafted regarding one of the instances in which the jury heard information they shouldn't have. The one I'm referring to is the gang members. You crafted an instruction, and I have the transcript of it, which I believe you said you would reread at the end of the trial as well. And I'll show it to you.
Yes, please.
You said you'd reread it, I think, in the sidebar, and that's not true, but on page 32 of the transcript of the proceedings on February 10th, right after we had the respective gang members, we went on for about a page and a half, and very carefully and aptly, I thought, pointed out to the jurors that when we hear these kinds of things, they have the capacity to disregard them, telling them to disregard them. In the next page or so, I think is what you indicated you were reiterating for the benefit of the defendants that had that testimony entered against them, and unfortunate as it may have been during the course of this trial.
But they didn't have any of that testimony entered against them.
Well, he said they're gang members in response to his response as to why he feels afraid.
Who were they?
Robert Allen. Remember he said they're gang members, and we had a long sidebar. The court gave the instruction that I just submitted to it, and the court said that he would reiterate a similar instruction, if not identical, at the end of the trial to make sure.
I don't know that I meant that I would, and I don't know that you want me to say, by the way, Alan said,
Well,
I'm scared of them because they're gang members, and I told you to disregard that statement, because then I'm just highlighting that
Right,
statement.
but not specifically, Judge. Just
No.
a general statement.
The
that-
other part of it, though, if what you're asking is, if you recall, when we started the trial, I told you from time to time you might hear something that I will tell you to disregard. It requires some discipline.
Yeah, something along those lines, Judge. That's
Just
what you indicated.
to make sure that you disregard anything that was objected to that I sustained or told you to
Just a little
disregard.
reminder at the end, because you know those things can pop up in deliberations and they have to.
I'm very comfortable doing that.
Thank you, sir. Understand?
I understand, I don't agree, but it looks like I've been overruled,
So
so.
I think it's on the record the court said you would put it in.
I'm conceding
And again, it's a
because
correct
you're- Denying the
statement,
mistrials.
it's a correct statement, and it's proper guidance.
Yeah.
I just need to, because I want it to look like another instruction. Yeah, you know where we can put that, I think, is under the, what is it, 311 cautionary?
Sure, that's where we go.
Where I tell them to disregard anything I may have said or done which makes you think I preferred one verdict over another.
As well as-
And then I could say additionally, I want to remind you again that you are to disregard any objections that were sustained and any comments that you may have heard that I told you to disregard.
Did you want me to type that in?
Yes.
Okay.
So you should.
Okay,
And
I didn't
if you
know.
want the transcript to.
No, I think it just needs to be
Yeah.
that short. So afterwards say, additionally.
Well, Judge, I'm not that fast. Okay. I just
Court
need to
reporter.
I just need to get to the part in the instruction. Okay, additionally,
You're able to get it down, right? Additionally, I remind you that you must disregard any objections that were sustained or any comments or questions that the court instructed you to disregard. Does everyone agree with that?
Yes, sir.
Yes, thank you, sir.
I drastically have to use the bathroom. Yeah, I got a lot.
I had one more matter to raise, Judge, that I don't think is, needs Mr. Biddy.
No, he needs to wait.
Okay, I'll mention it really quickly. Judge, in the course of the trial, you've given great latitude in terms of some of the rules of procedure regarding the funneling down of cross-examination, redirect examination. I understand technical rules so far, but when we get to closing argument, the problem in allowing that becomes, if the state doesn't address something in their closing, and I choose not to address it strategically, I don't want it to come up in a rebuttal argument when it has no bearing on what they said or I said. And in those circumstances, I'd ask the court to rule at this point to hold the state to a strict standard that rebuttal is in fact to be followed. If something hasn't been brought up in their closing or in any other closing, it should not come up in rebuttal for the first time.
Okay, so then he's asking that I just follow the rules of rebuttal?
Right, because
Kind of.
Essentially?
Yeah.
Okay,
Yeah.
so,
Rebuttal's rebuttal, it's not new argument.
okay, I'll follow the normal rules of
So,
rebuttal.
in other words, throw it all in there on your first argument, don't save anything for rebuttal, okay? Because I've seen prosecutors do that, you've seen courts allow it, but in this case, with all the landmines that we're trying to avoid, it's going to be very difficult for us to fashion a closing that doesn't, that addresses everything. If we don't feel something needs to be addressed, it shouldn't come in. And it should not be
The
introduced.
rebuttal argument needs to rebut arguments that are actually made on.
Either by the, by any of the
I understand,
defendants.
Mr. Rose, you don't
Yeah,
have to
okay,
explain.
so it's all agreed.
Okay.
Very good, thank you. So let's come back. What do you want, 3 o'clock? 10
No, it's not, if you want to even just get, I'm not gonna eat lunch, I'm going to.
Yeah, but I don't
do
know
this
if
and
these guys
email.
are, and Dia needs to use the restroom.
Somebody's going to be on, I mean, what?
All we're gonna do is we're gonna look over the final draft and make sure that it comports to everything that we said. So it'll be about a 15-minute hearing.
Okay, who needs copies so that I don't make unnecessary copies like I did earlier?
Just
Everybody take a moment and like the video. Hit the subscribe button.
On that same page, Mr. John?
On the Michael Boatwright Introduction to Homicide, at the very bottom.
It says Introduction to Homicide.
Title at the bottom.
Oh, it just needs to be,
Pushed down.
pushed down? Okay, give me a second. Because it may affect all of them. Hold on. Okay, so it didn't affect on features.
Yeah, and then
I just have to, insert a new page.
and then that messes up the first degree murder first instruction. But once you move it down, it should correct everything.
Right, so that's what I'm trying to do now. Okay, I think I fixed it. Now, let me, print just those 3 pages.
4 pages.
4?
Yeah, because the first degree murder one also printed at the bottom here, so hopefully it'll fix it.
It
So
did?
you're printing those 4 pages.
Okay. Okay, just printing, hopefully. Mr. Technical, this is asking what pages.
If they're correct, then you've got them.
Take a look. Mr. Reyes, Mr. Peter, want to see it?
Print me one more. I want 2 copies.
Thank you. Okay.
Oh,
Problem?
it's only 3 pages.
I printed 4. Wait,
First page of the homicide.
twice? You need it?
I need the last page again.
The intro to
First degree-
homicide.
No, the first degree murder one. That
Strategic Williams, first degree murder.
Okay.
I wonder why they in their jail uniforms today. I guess they're about to go into the jury or something after today. I don't know, because it only be taking like 3 weeks, 3 to 4 weeks for a trial. So this trial might be about over, and I think they're gonna deliberate probably like 1 day. You know what I mean? So I don't think everybody going to get the type of charges or sentenced it to the same time if they get found guilty. But we'll see. Let's get right back to it just like that.
that might be why I didn't print it.
I'm just gonna check it out. Can you please check if it has paper? There's paper right next to it. Open it first. Yep. What is it?
Good job.
Thank you. Yeah, and you just have an extra one.
All right. All right, so the 3 first-degree murder, premeditated.
Those accurately reflect the
Pardon?
They accurately reflect the
Yes.
court's ruling.
All right, then we have the felony murder, first degree, one for each.
All 3 of those pages are good.
Then we have the robbery instruction.
All 3 pages of the robbery instruction look good.
All right. On the LIO page, we don't have the LIOs listed for robbery.
Right, we need to add petty theft and assault.
Page 1, they're lesser.
Yep.
So change is to R.
Got it.
R robbery, petty theft, and assault. 22.
Okay. Thank you.
All right, then we have murder 2.
Those all look good to me.
And they appear on 4. Yeah, we don't need that first sentence because it's now part of the second.
Which one?
The
is it?
first sentence
Are
under
we
number
on-
2.
I'm sorry, are we on murder 2?
No, we're on man. Murder 2 is all good.
Okay.
Go to man.
Okay.
See how you have the defendant cannot be guilty of manslaughter.
Yes.
All right, that sentence is repeated as the second sentence of the next paragraph. So you can just take that first one out.
Versus. Oh, okay. So take out that whole sentence? Okay.
Yeah, because it's repeated as in the
Got it.
next paragraph.
And then I need to fix the bulleted numbers for,
Yeah, once again,
Michael
3, 4,
Bolton.
and 5, 6.
it needs to say 1. Okay. that the only thing to fix this minutes auto before I print it?
I believe so.
That's all that I saw.
Okay, I'll print 2 of each.
Thank you.
Okay.
I already see we're gonna have problems with the numbers on robbery as well.
Oh, same thing?
Yeah.
Yeah.
Oh, sorry, listen.
That's all right.
I'm doing this here. I can't. All right, hold on a second, let me just.
Yeah, let's get these ones up first.
Yeah, yeah. Okay, so that's page 20, 21, 2. Those are going to print.
You know, I don't want to throw hundreds of extra wrinkles in here, but given the length of these, it might not be a bad idea to have page numbers on the bottom, because I have had the experience before where jurors, I tell them, don't write on these, they're like, we got them all confused out of order, which one comes before which?
Okay.
And so maybe to help them keep them in order, maybe we add the page numbers back in.
Okay, right now, or by tomorrow?
Let's, yeah, by tomorrow. I just want to make sure the text on these is okay.
Okay.
But, counsel, what do you think about that?
I have no objection to these numbers.
Good idea, Jay. No objection.
Okay. I'll print the final copy in this day or before tomorrow, and I'll bring it with me to court.
Perfect.
Okay. Huh? I'm fixing the one, the numbers on robbery. Almost there.
Take your time. This is, it's also been my experience that no matter how many times we do this, how many sets of eyes look at it, typically when I'm reading them aloud, I find small corrections that we miss.
All right, I have it fixed for robbery. Anything else on robbery before I print it?
Nothing else that I see.
Yours be good.
Okay, I'll print the copies. I know it might.
Nope. No.
No, okay.
Well, on this one, the one came up.
I can't fix it. I don't know why. I cannot fix it. I tried. And then when I tried to fix it, it messed up the margins. I can show them and see if they have an objection.
It's all right. Show, let me see what copy, it's just like this.
Okay. What's the issue? It literally has like a little line through it. I don't know why. I just printed that. It's very easy. You have an objection to that.
You okay if
He doesn't have
it's
an
like
objection
that?
to it.
Any
It's
big
fine. He
objection?
doesn't have an objection.
That's gonna be the turning point of the case?
Yeah. I'm flabbergasted.
Okay.
Okay.
That's not an outrage for you?
That's an outrageous thing.
All right, on petty theft, so we're all good up to there. Now, on petty theft, I don't know that we need any of the things that follow the two elements, because grand theft is not a necessary lesser, cat one lesser. Only petty theft is. And petty theft doesn't deal with valuation as an M2.
I agree, I had that highlighted as something.
Yeah, if you find the
Taken out.
defendant guilty of theft and then it talks about 20,000 to 100,000 or any of those other things, we don't need any of that.
Okay, so take out.
Everything after sentence 2, the if you find, the value, and the exact value are not elements of petty theft.
Okay.
Everyone agree with that? Yes?
Yes, yes, sir.
Okay, that's printing now.
All right, then we have assault.
I would just request that under problem 1, it looks like.
Yeah, you got the
A-
parenthetical victim.
Yeah, parenthetical victim, I would just request the
I think
parenthetical
you meant
victim.
to take that out anyway.
I did. Oh, I have it on each one, huh?
Yep.
Okay, anything else? I print it?
That'd be it. Boatright and Newsom.
They both look fine to me.
They appear to support, yes. Then we have principals.
That's a little fine.
Yes, they do. Then we have plea of not guilty, reasonable doubt for proof.
Looks good to me.
Then we have weighing of evidence.
I think we're supposed to know the other one's for Holman.
Then we have testifying. Fine. Then we have defendants outside of court statements. Then we have the eyewitness identification. So far, so good?
Yes, sir.
Yes, Judge.
Yes, sir.
Rules for deliberation.
Looks good.
And, Mr. Raris, you see the added sentence on there that sufficient to address your.
Let me just, put on one of the.
Yeah.
Other counsel.
Second.
Thank you, Judge. Appreciate it.
And the verdict instruction looks correct. Everyone agree?
Yes.
Yes, agree that it accurately reflects.
All right, now, looking at verdict form for Mr. Williams, count one, here's correct.
All right, you see, Mrs. Buckley pointed out there's something wonky about, one of the verdict forms, for Trayvon Newsom, count one, and,
Well, hold on, let me look at,
Okay.
all right, they're good for Williams.
Well, hold on.
Count
Mine
one.
doesn't have lines for the 4 people to sign.
Or count,
What it previous judge, do you have lines for the 4 persons?
Mine has lines.
So it's
Yeah.
just your pagination on your Word version.
Okay.
And on count two also,
count one and count two seem, okay, and they have lines,
yes.
okay.
Then, all right, verdict count one, vote right. That appears correct. Count two, yeah, you have the spillover of the.
Yeah, I fixed it already, so.
But other than that,
I don't see any issues.
okay, so that also means you're gonna have to redo count one of Newsom.
Of Newsom and count two of Michael Boatwright.
Yes,
Okay.
but otherwise, they appear correct.
Okay, those are clearing now.
right, and then for some reason certificates here in the middle there.
Middle?
They're right, you have them right after verdict forms.
Why are those where you wanted them? You wanted them literally dead last.
The certificates, I don't even send back there with them. I sign these and attach it once they come back.
Okay, so on here, for the final one, I will put them dead last.
Yes.
So that they're not part of the pagination.
Correct.
Got it. So let me cut and paste it. That's my fault. I thought that's where you wanted them.
Yeah, no, it's not, must have misspoke, but. Yeah, I don't even usually send the certificate back with them. I just, once they bring it back, I attach it as these were the charges that were given.
I don't need to reprint that since you're just, okay.
Just moving it. All right, so after the verdict form, last one we looked at was nuisance count 2. Then we go to the multiple counts. Does that appear correct?
Yes, sir.
And then multiple defendants.
Yes, sir.
And then submitting the case to the jury.
One thing I noticed on that was the next to last paragraph. It says these exhibits will be sent into the jury room with you when you begin to deliberate. I think you indicated.
We were gonna put on there with the following, with 2 exceptions.
2 exceptions.
I was gonna say rather hallway. Do you think it's
Submitting the case to the jury. I think possibly,
Okay, so the sentence will read, these exhibits will be sent into the jury room with you when you begin to deliberate with 2 exceptions?
yeah,
Okay.
I should probably be comma with 2 exceptions.
Okay.
Well, that's not particularly great grammar.
He's looking at the English teacher.
I think it's just fine.
Okay, so that's it? I'll reprint that page?
Yeah.
Okay.
I think that's like a dangling particle or something, but whatever, we'll be all right.
Okay.
All right, so that's the last page, and then the 3 certifications follow that.
Yeah, I already changed it and added back in the, pagination.
I see that these already have 54 written on
Oh, yeah, sorry.
them. Yeah, but that's good. All right, so these would be 55, 56, and 57, right?
Yep.
Okay. Then everything appears to be in order. And if you will, just, since the only thing that's changed is the page numbers, if you'll just bring me a copy of that in the morning, I will compare it to these. And that will be the official copy.
Okay,
I'll just need one.
okay. I have to bring one for the court first, so I'll just bring 2.
You'll email them to the parties.
What's that?
You'll email the final set to us.
Yes, I'm gonna do that right now, actually.
So Judge, I agree that the jury instructions are as the court rules. Would
Preserving all
that we're
objections.
preserving and renewing all objections previously made, both for the jury instructions as well as throughout the trial.
Gotcha.
Mr. Newsom, I renew and
Stay the same.
Oh, yeah, I'm not sure whether everyone knows it.
Noted, thank you. All right, last thing we need to discuss today is how much time, state how you want to split yours, and what sort of warnings everyone wants.
4 hours, 1 hour for rebuttal. I do not need time. I prefer to keep my own, if you recall, and it'll be 3 hours on the front end, 1 hour on the back end.
3 and 1.
Say it again?
So 3 and 1.
3 and 1.
Mauricio says he does not want to speak for 4 hours. You're not compelled to.
No, I don't even know what to say.
Well, I do have 3 defendants that I'm, so.
I didn't say no.
Oh, okay.
I'm just asking, so, you guys are entitled, I'm not going to limit you within reason, and you're all experienced counsel, so I don't have to, even though I am now, I don't have to remind you that, becoming repetitive and just saying things over and over again, you do so at your own peril. You start losing them, that's on you, so you can be as boring as you like, but your clients won't appreciate that. So, do you have an idea how long your closings will be?
An hour?
And again, you can certainly take more than that.
Okay.
George?
I would ask for an hour and a half, and it would probably be closer to the hour
Okay.
when we get there, hard to say.
Okay. So,
Yeah, I would say 2.
all right. Do you want any sort of warnings?
I'll take a warning at, yeah.
You want a warning after 1 hour and then,
I don't need a 1 hour warning.
Okay.
Just a 20-minute warning.
all right.
I don't request a warning.
Okay,
That's fine.
Mr.
I'll take one. Like a land the plane warning? Yeah, I'll take one.
How many?
20 minutes is fine.
20?
Yeah.
All right, 20-minute warnings. And again, right, so 3 and 1. Mr. Boatwright's looking for around 2 hours with a 20-minute warning, not compelled to use every last minute. Mr. Rare's looking for about an hour and a half, no warning. And Mauricio, you'll get a warning after 40 minutes.
Let's just do a warning at an hour. That means that I warned longer than I thought. And then-
Okay, so you'll just tell them when an hour's passed,
right.
and then you'll wrap it up.
Right.
Okay. And if you don't,
Yeah,
if you
okay.
finish before that, you finish before that. Understood. All right. So there's a probability, unless people use way less time than they think, that it will spill into Wednesday.
How many cases are in the docket? You said what's going to spill into Wednesday, the closings? You think so?
If you take 4,
Yeah.
Well, I may not take
And-
all 4, but I'm
No,
requesting it. but-
I'm just saying, if everyone uses as much time as they've said here, at least one of them is gonna end up going on the next day, and then I'll be instructing on the next day.
Okay.
Which is fine, But if you only take like
3
an hour and a half on your front end, then, and you only take 45 minutes, it all depends.
Okay.
I'm not suggesting, I'm just saying, it would almost have to be that short in order to get through all of these plus rebuttal in one day. And then either way, by the time we get done with that, I'm probably not instructing them until the next day either, because I don't want to instruct them, send them home, and then have them deliver it. I want to instruct them and send them out, so.
Okay.
Yeah, no stress.
And we're stopping around 5:30, we won't go late just to get everything in.
When you say that one of them is gonna end up bumping, it'll end up being me, is my.
Well, it might be your rebuttal, or it
Oh,
might be
okay.
one of them plus the,
Oh, okay.
whatever time it is. You know,
Got
again,
it.
we'll finish sometime between 4:30 and 5, and wherever we're at that. And, you know, I'll let the person finish up, whoever's there. But if it's like 4:30 and someone hasn't argued yet, I'm not gonna have them start with 30 minutes left. We'll bump it to the next day. I'm going to try and avoid breaking up someone in the middle of their argument.
Just curious, when they're deliberating, are you gonna allow them to deliberate past 5 if they want?
I don't tell them. I call them out when I want to send them home. So what happens is, let's just say they get put out at 1 in the afternoon or 2 in the afternoon. I let it go around, we reassemble around 5:15 or so. And then I usually call them out and say, okay, folks, we're going home. And even if they say we're kind of close, I say, that's wonderful, we're going home. Because I don't want them to think, all right, now we got to go back and finish up really quick. You know, I don't want them to ever feel that they have to reach a decision by a particular time. And sometimes, unless the closest I've come is where I've called them up to send them home, they said, we're literally signing the form now. Oh, okay, then go do that. But anything short of that, then I don't want them to say, all right, we're done discussing, judge wants to go home, or whatever. We're not going to do that. So when I call them up to go home, they go home.
Okay.
All righty, unless there's something else. See you guys tomorrow at 10:30
Okay.
or 10:25.
I don't remember what time it was, yeah. We might get here a little early out.
Come in early. Early is good. Late
Stuff
is
like that,
bad.
yeah.
Early is good.
Yeah, I'll bring your copy tomorrow. Okay, I'm bringing a copy. So,
Actually,
Ronnie, stay giant. With our strongest brownie ever, so you can use less.
Press, gossip or other stories that may be out there. And with that, last Friday, that's good. We got a couple days off. Monday morning, 10:30, in the reception area again. Hopefully all of you already have whatever letters and things that you need. Yes? If anyone needs anything further, again, don't hesitate to let one of my deputies know, and my judicial assistant will make that happen. I think that's all we need to go over with you folks. So again, have a great weekend, and we'll see you Monday morning at 10:30.
No court till Monday. Everybody have a great weekend. I'll be back live on Monday. Please, everybody, thank you for.
Expedited as a transcript for the state, so
Okay.
that we can have it.
You got the checkbook, you can have
Yep.
whatever you like.
Please, just that. That's all we need for our argument and what we're gonna address on Monday. Thank you. It's a weekend, so.
Yeah, they be back on Monday. Please, everybody, thank you for watching the live. Please comment guilty, not guilty, or it's gonna be a hung jury. Please, everybody, share this video, share this live. Hit the subscribe button when you know I can go live. Please, everybody, hit that